Hello, everyone. Welcome to today's session. I am super excited. Today we have Michael Marcogliese, and he is from Brazo Seller Law. And Michael today is actually going to be talking about you will be learning about how to incorporate your business and a lot more about shareholder agreements and licensing and more. So Michael is actually a corporate lawyer. So we are so excited to have his expertise. And I'm sure you guys are definitely going to benefit from everything that he is going to teach you today. You can leave your questions or any questions that you may have in the chat or Q&A box. And as they come up, Michael will be happy to respond to them and answer them to the best of his abilities. And if he can't answer them at the moment, then you can definitely get in contact with him afterwards so he can answer your questions. So I'm going to pass it along to you now, Michael.
Thank you, Chizoba, and thank you everybody for joining us today. It's a real pleasure to be here, and I want to thank the Founders Fund team for reaching out to me to present to you all today. So I'm Michael. I'm a lawyer. I'm an associate with Brazo Seller, and I'm going to be speaking to you today about your business, things to consider if incorporation is right for you, and then after incorporating, some considerations such as estate planning and some types of agreements that you will want to consider to improve your business practices. So without further ado, we'll kick it off. So just a brief disclaimer at the beginning is that nothing in this presentation is intended for it's provided for informational purposes only, and none of the information in this presentation is offered, nor should it be construed as legal advice on any matter. Nothing in the presentation shall create or is intended to create a prospective or actual solicitor-client relationship between you and any other person and our firm or any of our firm's lawyers. So just keep in mind that if you have any legal questions specific to yourselves, I invite you to reach out to me after the presentation, and my contact info will be there. But I'm happy to, as Chizoba said, answer any general questions that you may have during the presentation. Okay. So for starters, I'm sure most people who are attending this presentation are aware of the different types of business structures, and the three most common forms are sole proprietorships, partnerships, and corporations. And probably many of you right now are operating as a sole proprietor, and many businesses are organized this way. And we'll go through some of the advantages and disadvantages of each type of business structure, because depending which one you choose to operate under, that's going to have very important consequences on how you manage your business down the line. Like I said, how it will affect how you are taxed. It'll dictate succession planning. And these are all major considerations when you're first starting out and looking to get your business going from the very beginning. So we'll move it along here. So we'll say that, a sole proprietor. So what is it exactly? So this is where an individual carries on business in his or her own personal capacity with or without the assistance of employees. And now most sole proprietorships are a one man or one woman show. They do everything from start to finish. So I always give the classic example of, let's say, like a plumber, an electrician, or somebody who's in trades. Doesn't have to be that. It could be somebody who, does home staging and decorating, stuff like that. But the point being is you operate in your own personal capacity. You operate under your own personal name, and you can register a trade name. So, in the case of a plumber, you could register a trade name, Mr. Plumber Ottawa, or wherever you're located. But the point being is that you're operating under your own personal name as a sole proprietor. And the benefits are that the profits are paid to you directly as an individual. And are also relatively very inexpensive to set up. The cons, though, are that you are responsible for the business and its debts. And if there's anything owing by the business, you as the individual would be personally liable to repay those debts as well. And income tax as well, you're taxed at the personal tax rate, which is generally which is much higher actually than the corporate tax rate. And I'll delve into that a bit later as well. I'll give you some more details on the differences between the personal income tax rate and the corporate income tax rate and why it may make sense to incorporate. And we'll go through over some of that. But the major, takeaway is that operating as a sole proprietorship, the disadvantage to operating that way instead of a corporation is that there's no limited liability. So again, all the business's personal assets may be seized in satisfaction of, the business's obligation. So you can limit your personal liability exposure through by contract. So having very carefully drafted contracts, or through insurance to cover like any work that you're doing. If anything were to come up with regards to work that you've performed or services that you've provided to individuals. So those are some considerations for sole proprietorships and pros and cons. So another business structure is partnerships. So partnerships are most likely less common. They are certainly more common in the settings of a law firm or an accounting firm. Those are generally known as limited liability partnerships. But if you were looking to start a partnership with an individual or another partner, so they're typically two or more individuals combining resources and operating a business together with a view to turning a profit. It's normally be a general partnership. And what you would have is a partnership agreement between the parties, just setting out how expenses are paid, how the income is going to be split, the goal of the partnership. So those items would be set out in a partnership agreement. It would also set out how partners are expected to exit the partnership if there's something to that effect. Partnerships, like I said, are a lot less common, and usually those looking to form a partnership will instead just form a corporation. But they're easy to set up with low startup costs. Like I said, expenses are generally shared between the partners along with the profits. But again, that is subject to a partnership agreement and what the agreement can, sets out. Cons, I mean, if you don't have a partnership agreement, it can be difficult to reach decisions. If you do have one, then how to reach decisions will be set out in there, and there should be clear mechanisms on how those decisions can be reached. And if you can't reach a decision, well, perhaps there's a mechanism for mediation or arbitration or a way of working through the issues. And as I mentioned, so general partners are in a partnership are personally liable for the business debts as well. So again, there's no separation of liability. So there's no limited liability. So as an individual, you again would be personally liable for the business debts and the obligations of the business. Okay. So corporation. So it's going to be the crux and the main focus of the presentation. So what is a corporation? So a corporation is a separate legal entity in law, and it allows the owners, it's separate in law from its owner. So what that means is its own legal entity. So it can own property, carry on business, possess rights, and incur liabilities. So although shareholders own the corporation through ownership of the shares, the shareholders do not own the property of the corporation. So again, the corporation itself is its own separate legal entity. It can own its own property, and it can exist in perpetuity, meaning that there's no, it can go on forever, a corporation. So that's one of the main considerations in incorporating is if you're looking to incorporate a business and have it survive your lifetime, then that would be a good way of structuring your business as a corporation from the beginning, because obviously a sole proprietorship, when you pass away, the business will end with you, whereas with a corporation, the business can continue on. So some of the pros and cons. So personal liability, there is none to the shareholders. So again, there's this separation of, of ownership and its own legal entity. So again, whatever debt obligations that the corporation has, that is the obligation of the corporation and not of the shareholders. So unless the shareholders have given a personal guarantee a debt, then they would not be liable for the repayment of those debts or the performance of those obligations. So there's that separation of liability, which is a big pro for wanting to incorporate. The other one is you benefit from many legal and tax advantages that are attached to being incorporated. I'm going to touch on those in the next couple of slides. And the other advantage is if there's any income left over after your, your taxes, expenses, any of that is paid, that can be paid out as a dividend, again, at a more favorable tax rate than if you were working or, as an individual and paying yourself out, just a salary. Again, you can take advantage of the, pros of having these tax advantages of using a corporation. So some of the cons, obviously it's more expensive to set up. It's more expensive to maintain. You have to compile financial statements. So you need to pay an accountant to compile those financial statements. It could be roughly, a few $1,000s. And you have reporting requirements. So if you incorporate, you can incorporate in Ontario in one of two ways. You can incorporate provincially or you can incorporate federally. Now, you'd either be governed in that case by the Ontario Business Corporations Act or the Canada Business Corporations Act. The provisions of both acts are very similar with some slight differences. So I'm not going to delve into that, but the main difference is whether you intend to operate across Canada or whether you intend to operate just in Ontario. So going back to my plumber situation, if example that I gave before, so if you're looking to incorporate, but you're going to only operate in Ontario, it would make sense to incorporate under the Ontario Business Corporations Act instead of the Canada Business Corporations Act, because then you have, when you incorporate under the Canada Business Corporations Act, you have dual filing requirements. So you have some filings to do under the CBCA, and then you have some filings to do under the OBCA. Whereas if you just incorporate under the Ontario Business Corporations Act, you just have one filing requirement. But again, that means that if you want to operate in other provinces, you'll have to file what's called extra provincial jurisdiction. But if you're going to be operating across Canada, then the recommendation would be to incorporate under the Canada Business Corporations Act, and then you can operate in provinces across the country. So a few things on naming corporations. So, and this is always something to consider, is that you can't use offensive or objectionable words. You can't use words that are connected with the Crown or any level of government. And, I would always say, try to choose a name that is inherently distinctive, something that is reflective of your business, that, denotes to your consumers or the people that you're providing a service to, like an origin of some kind, so that when they hear their name, they can tie to, that type of business. So it denotes origin, which I always think is a good thing when choosing a name for your corporation. And one thing that you need to keep in mind is just because you incorporate and you've registered a business name, that doesn't provide trademark protection. So if you don't have a trademark and you continue and you begin operating under a specific name, you will acquire what's called some common law rights. But it's, if you intend to, really have exclusivity to that name, I would, recommend that you speak with an intellectual property lawyer and consider trademarking the name, because then you'll have use of the name across Canada. And once you have that trademark, it will grant you greater protection and make it easier to police your trademarking rights. So consider getting a trademark if you're really thinking about being out there and marketing the name of your corporation, of your business. So I often get the question, people come to me, they say, Mike, how do I know that incorporation is right for me? And I always say, well, ask yourself these few questions, and this will help you this will give you a better idea. So am I earning more than I need to meet my daily living expenses? So incorporating makes sense if, and I will give you an example in the next slide, is if you're able to keep a certain amount of money in the corporation after you've paid for your expenses and your salary and stuff like that. So once you're able to keep some money in the corporation, that you'll see is taxed at a much favorable tax rate. And then you can use that money to reinvest elsewhere. You could buy some property or just invest it back into the business. So that's one consideration. So the other consideration is, do you want to save money for retirement, potentially leave something to the beneficiary? So again, this comes down to, do you want to pass something on to, potential family members if you're running a family business? Do you want to, maybe your spouse is involved in it with you, maybe your children show an interest in the family business, and you want to pass it down to them. That's another consideration. And it's also ties into the third bullet on the slide there. So again, a corporation makes succession planning much easier, and I'll delve more into that later. And the other consideration is, do you plan to sell your business? So let's say you don't have any family members, you don't want to pass on the business to children, or they don't have an interest in the business. And well, ultimately, if you're looking to retire, it's much easier to sell a corporation than it will be to sell a sole proprietorship, which at that point, most likely they would just be buying the assets of your sole proprietor, like let's say, any equipment or anything like that you may have. So it makes it easier to sell the business. If you're looking to sell shares, I'll deal with that later towards the end of the presentation. I'll tell you what, one advantage that you can take advantage, one thing that you can take advantage of with regards to a share sale. And the other thing is, are you incurring significant business expenses? Because some of those expenses can be used, as a deduction, for your business. So those are all important considerations. So some tax advantages of operating through a corporation, to name a few. So, corporations get taxed at lower rates. You have potential access to small business deductions. You have the ability to reinvest tax savings, and you have the potential access to the lifetime capital gains exception if shares in the corporation meet the technical criteria of a qualified small business shares. So that would be on a share sale, which I mentioned I will touch on later. And there's the potential for some income splitting with family members. Now this was scaled back a bit by CRA, but there's still the potential for a little bit of income splitting. So there, and I should mention that if you're thinking about incorporating, it's probably a very good idea to touch on the subject with your accountant. I'm not an accountant. I'm not an expert on tax advice, and I do not give tax advice typically within my practice. So it's usually something I leave to the accountant. So these are just, like I said, some easy examples of things to consider, and conversations that you should have with your accountant about, the potential tax advantages of incorporating, and, whether it makes sense for you. But once you've had that conversation, if it does make sense, then by all means, feel free to reach out to a lawyer or myself, and we can definitely, set up the corporation for you. But, those tax advantages should be reviewed with your accountant, because everything is case specific too, right? So it's all based on your specifics, your needs, and your business, more importantly. So again, to give you a basic tax example of, some potential savings, that you could achieve through incorporating as opposed to operating as a sole proprietor. So we'll go through here. So in Ontario, the corporate tax rate is 12.5% on the first 500,000 of active business income that you earn. So active business income is income that is not investment income. So if you just have a business that owns real estate and it just collects rents, that is not active business income. So I always think of active business income as, let's say you have a brick and mortar store and you have people walking through the door and they're purchasing items off the shelf like that. That is something, an easy example of active business income. So any income above 500,000 is taxed at a corporate tax rate of 26.5%. So by comparison, if you're operating as a sole proprietor, and let's say my plumber example, let's say you have a phenomenal year and you earn 220,000, then you're going to be taxed at 53.53%, much higher than the 12.5% tax rate. So for corporations, so we'll take my example. So we'll go through example one. You've got a personal, you've got a sole proprietor on the left-hand side. So like I said, John is a plumber. He earns 250,000 a year operating as a sole proprietor. So you've got the example there on the left-hand side. So 250, he has operating expenses of 52,000. And then he contributes to his RSP of 27,230. And then personal tax that he's going to pay on the 170 that's left over is 56. So after tax personal cash, he's got 114,000. Then he's got living expenses. So he's going to be left with $24,770. So that's what he's left over because he's in the highest personal tax bracket in Ontario. He's being taxed at 53.5%. So he's got that much larger personal tax payable at $56,000. So by comparison, if he was operating through a corporation and the corporation earned $250,000, and let's say he had the same operating expenses, $52K, he pays himself out a salary of, let's say, $152,000, then he's going to have taxable income of $46,000. And the corporate tax rate in Ontario, like I said, is 12.5%. So he's going to be taxed basically $5,750. So after tax available for investment when it's all said and done is $40,250. And that's because of the corporate tax rate in Ontario at 12.5%. So what that means is if you take $40,250, you subtract $24,770 from it, then he's going to be left over with a lot more cash. He'll have roughly $15,480 left over to be kept in the corporation. So again, remember I mentioned at the beginning that if incorporating makes sense if you have enough to support your living expenses. So assuming you can leave some cash in the corporation, because it's the cash that's left in that gets taxed at the much lower tax rate of 12.5%. So assuming you can do that, then it would make sense to incorporate because you'll have more money left over in the corporation. So in this example, you'll have 15,000 more, and then that money can either be used to purchase assets or can be used to be reinvested into the corporation. So assuming that he can continue to live off of 100 and where we say his operating expenses 52,000 and then a salary of 152,000. So assuming he can live off that salary and keep the balance in the corporation, then that would be good. As opposed to if he was operating as a sole proprietor, he earns 250,000. If he needs the whole 250 to, for living expenses, then most likely, incorporating is not going to be the right move for him. So that is one of the biggest considerations for incorporating, is whether you're able to live off of, the money that you're earning and leaving some in the business. So another advantage of incorporating is, if you can't hire family members to carry out work, you can make them shareholders, you can pay them dividends. Again, there are some rules now that have restricted income splitting, but depending on personal incomes, there may be some tax advantages. And then you have the advantage of some rollovers as provided by the Income Tax Act, which are important tools for corporations that are used to defer taxation for certain transactions, especially in complex corporate structures. And the purpose of a Section 85 rollover is you transfer assets from the taxpayer to the corporation. And what happens is you defer the payment of tax on those assets that are being transferred. And actually, the most common example of this is used when you have somebody who is self-employed as a sole proprietor and wants to incorporate his or her business. They want to avoid the immediate taxation on the transfer of assets by transferring those to the newly created corporation. So, your accountant may recommend an 85 rollover. So we're already there just at the very beginning, before you've even incorporated, you're already, receiving a sort of like tax deferral, tax, break, just, from merely just wanting to incorporate. So a lot of tax advantages for incorporating. I think I have one more slide. So again, if you want to transfer here, so here's an example of an 85 rollover. So you transfer real property, capital property to your corporation. Your cost of the property is $200,000. The fair market value at the time of the transfer is $500,000. So as consideration for the transfer, the corporation has to give you some shares. So you end up, as a new shareholder, you end up subscribing for 100 common shares. So now you're the shareholder of your company. So assuming you elect that the transfer of the property is at $200,000, there's no capital gain. So there's no gain on the transfer. So the corporation's cost of the property will be $200,000, and your cost for the shares will also be $200,000. So note that, there won't be a gain, but this is essentially just a deferral of tax rather than a complete exemption of tax. So if those corporation, would go to dispose of that asset later, yes, there would be most likely a capital gain, but at least this gives you the ability to get the asset into your corporation on a tax deferral basis if you're looking to, go from a sole proprietor to a corporation. Okay. I know some of these things are maybe like complex tax questions, but again, a good conversation, at the start can be had with your accountant, and he can walk you through a lot of these tax considerations when you're looking to incorporate. And a lot of times they, it'll be more clear to you, especially with regards to your specific business, and it may make more sense to you once once you hear these terms in the context of your own business. So licensing. So I'm going to speak, just a tiny bit about licensing. If you have a trademark, I touched on this at the beginning, licensing is all about control. You want to make sure that the character and quality of the goods or services that you're licensing or the trademark is being treated properly by the individual or the group that you've licensed it to. So license agreements need very careful drafting, especially with regards to the control provisions. So you want to make sure that, while you are giving, a license to another party to use your trademark or perhaps, sell products, of yours or provide services of yours, you want to make sure that, the ownership of the trademark or goods or services that are being licensed is not confused, and that you want to be able to maintain that control, take back control if, the party that you've licensed to is, operating in a manner that is, devaluing the goodwill of your product or services or trademark. So you want to be able to maintain that control, take it back. So that's, that being said, again, this is a very complex document. You want to make sure that it's very well drafted so that you can maintain control. And you want to make sure that the item that you've licensed, like I said, whether it's the actual name of your business, whether it's goods, whether it's services, you want to make sure that the person is going to be adhering to the necessary standards that you've set. And if they're not doing that, you'll want to rescind the license and basically end the agreement. So it's best if you want to discuss licensing, discuss it with an intellectual property lawyer. They're often the experts in trademarks and licensing trademarks. So that's also a good conversation to have. So another agreement that I always get a lot of questions on, and something that Josova asked me to touch on in this presentation, are shareholder agreements. So shareholder agreements is basically an agreement between two or more individuals or shareholders of a corporation, and is a common tool used to set out corporate governance of the corporation and manage risk. So let's backtrack a little. So perhaps you were a sole proprietor, you've decided to incorporate. Now you've got a business partner in the corporation. You're both equal shareholders, and you want to make sure that the relationship between you and the other shareholders, is managed well and set out from the beginning. So one thing to remember is that, a shareholder agreement is first and foremost a contract, and there are fundamental requirements for it to be binding. There must be offer acceptance and consideration and capacity, and, a bona fide, will to be bound by, legal purpose. So you want to keep that in mind, because it is a contract between individuals, and there's no one size that fits all model. So I always, liken shareholder agreements to getting, tailored for a suit or for a dress. You have to very much tailor it to the specific business needs, of your corporation, of the shareholders. So I've drafted, shareholder agreements as, were simple and perhaps 10 pages in length. And I've, been asked to draft more complicated ones that were, there were more than two shareholders, and they wanted to, basically, cover as much as possible, and ended up being, roughly a 30-page agreement. So it all really depends on, as shareholders, what the agreement is amongst yourselves and what you're hoping to achieve. So the most, one of the most common types of shareholder agreements is called a unanimous shareholder agreement. So the unanimous shareholder agreement is one in which there's a written agreement between the shareholders of a corporation, and they're looking to restrict in whole or in part the directors or how they manage the business and the affairs of the corporation. So it's a good idea to keep in mind that in a corporation, there are multiple parties. Now, in the context of a small business, or a family business, you may end up wearing all the hats. So, in a corporation, you have directors and officers. So the directors are, in charge of managing the day-to-day operations of the corporation, whereas the shareholders are just the owners and don't really participate in the day-to-day management of the company. And the shareholders, elect the directors, and then you have officers such as the president, vice president, secretary and treasurer, and those positions are appointed by the directors. So the shareholders agreement will often limit the powers of the directors to manage the business because they want to, try to maintain some type of control over the business. But in small businesses, in fact, in a lot of the ones I see, you've got one shareholder, one director, one officer, and they're all the same person. Or if you have two individuals, well, then they're both directors and they're both officers. Maybe one's a president and the other is the secretary and treasurer. So again, as you can see, each business is unique. And if you're going through or asking a lawyer to draft the shareholder agreement, there will be a bunch of questions that they'll be asking you just because, like I said, it's tailored to your specific business situation. So a well-drafted shareholder agreement will have several goals. So it sets out the obligation and entitlements of shareholders and other key stakeholders. So it should attempt to reasonably anticipate events in the future, such as changes in ownership, need for additional capital if you guys need to raise capital either through, private financing or through a financial institution. Resolving disputes between shareholders is a big one, and one that I will touch on later. And what happens on the death or disability of a shareholder. So what happens with that individual's shares in the corporation, once they've passed away or they're disabled and can no longer really participate in the business. So, and as I said, a lot of the common issues between shareholders, is dealt with regards to the transfer and sale of shares. So you often hear terms like shotgun clauses, right in first refusal. So I will touch on those in the presentation. So those are all things to consider, and we'll move along here. So again, focusing on the rights and restrictions of shares, breaking the deadlock between shareholders. So, why this is important. So essentially, if you are a shareholder in a corporation, whether you have one or more other shareholders in the corporation with you, and, you're all in the business together, what you often want to, protect against is, you want to make sure that who your partners are. So in the event that one of your partners or one of the other shareholders wants to sell their shares, you don't necessarily want them selling their shares to a third party because you don't know, anything about that third party necessarily. You don't know if they're going to come in and basically rock the boat of the business. Maybe it's going to disrupt operations to have someone new that you're not familiar with. So these are all, legitimate concerns that shareholders typically have. And how do you deal with this? Well, you deal with these in the shareholder agreement through either a right of first refusal or a right of first offer. So a right of first offer. So we'll start with this one. So a shareholder is looking to exit the business and sell her shares, but must first make an offer to sell the shares to existing shareholders on terms that the seller is prepared to accept. So as an example, let's say you're two shareholders in a corporation, you're 50-50 owners. One wants to exit the business and is looking to sell their shares. Well, before that individual, the selling shareholder, can offer her shares to the public, they must first offer the shares for sale to the other existing shareholder. So again, it gives the existing shareholder the opportunity to buy the shares, keep them together, because they won't necessarily want 50% of the shares going to someone who they're not sure, and then they're going to be in business with an individual who they may not gel with or know anything about, but also they may want to keep the business 100% for themselves. So the remaining shareholder can choose to accept the offer to buy the shares. But assuming they do not, then the selling shareholder can sell their shares to a third party. And if depending how many shares are being sold, if the existing shareholder does not accept the offer, then they risk losing control of their corporation. So, another incentive for them wanting to purchase the shares from the selling shareholder. So our right of first refusal is sort of in the same situation, except in this case, a shareholder looking to sell their shares obtains a bona fide offer from a third party. So instead of, in the first example, the shareholder is going out looking for somebody to sell their shares to. In the second example, somebody has come to them with an offer to sell their shares. So if they are prepared to accept that offer from a third party, then the remaining shareholders will have a right to acquire those shares at the same price and on the terms set out in the third party offer. So again, so if somebody says to, let's say you have a partner, a shareholder in a business, there's two of them. Somebody goes to your partner shareholder and says, I want to pay $50,000 to buy your shares. Well, before you can sell them to that third party, the other shareholder has the option to purchase them first. Again, they have that right of first refusal to buy them, instead of you selling them to the third party purchaser. So again, it gives them the opportunity to, keep control of the business and not risk losing control of it. So a shotgun clause. So I'm sure many of you have heard this term before. So again, this is different from a right of first refusal and a right of first offer. So, it's most common in situations where there are 50-50 shareholders. So a lot of times if there's a breakdown in the relationship between two shareholders who have equal power or equal shareholdings rather, and, one wants to exit the business, a shotgun clause, is a, pretty aggressive way of going about it. But if all else fails, and I'll touch on some other, potential resolution mechanics, but if all else fails, how it works is a shareholder delivers both an offer to buy the shares of another shareholder and also an offer to sell her shares to the other shareholder on identical terms. So, it would be perhaps you going to, let's say, your partner in the business and saying, I want to sell to you my 100 shares for 50,000, or I want to buy your 100 shares in the business for 50,000. So the other shareholder must then decide of the two options which they prefer. Do they prefer to sell their shares or do they prefer to buy their shares? Now, some important considerations. A lot of time in these businesses, the shareholders may not be of equal bargaining power. So one may have access to additional financing. $50,000 is a lot of money. So, it's possible that one shareholder doesn't have the opportunity to raise the money to buy those shares, so they have no choice but to sell. One shareholder may not have access to determine a fair price for the shares or the ability to carry on after the sale, as the sole shareholder of the business. So again, I'm giving these examples, I'm making these comments in regards to an example where, it's small businesses, and there's only a couple of shareholders, maybe 2, 3, or 4, and in the case of much larger corporations, some of these examples may not be the same. Some of the considerations may not be the same, but oftentimes in sort of these smaller types of transactions between family businesses and stuff like that, if there's only one individual, they may not be able to carry on the business, by themselves. Because as I said, typically, the shareholders will wear all the hats. So you'll be, the shareholder, director, and officer, and you manage the business from start to finish. So it may be difficult for one person alone to carry on, whereas it may be easier for another person to carry on. So, that's an important consideration in a shotgun clause is the bargaining power of both parties, And another thing is, in each of these scenarios, determining the share value is often something, is a mechanic that needs to be dealt with in the shareholder agreement. So oftentimes, the selling shareholder will often say, I think the business is worth more, or the the shareholder who may be buying is going to say, well, no, I think the business is worth less, because obviously they want to pay less for the business. So determining the value of the shares is often a key consideration in drafting a shareholder agreement. And oftentimes you'll want to use an independent accountant or business valuator. And if you each have your own valuation for the shares, you need a method for breaking that deadlock. So, it's one thing to exercise the clause, but there's still negotiating in the, that needs to go on as with regards to the purchase price, and perhaps even like timeline as to how quickly, the sale of the shares needs to take place. So, and sometimes, if shareholders disagree, you don't have to go ahead and exercise a shotgun clause. I would say that that's typically usually a last resort move to be made. So there are other methods for resolving disputes between shareholders that you can deal with in a shareholders agreement, such as setting out mediation or going to arbitration. So if that's the case, then you'll want to set out in the shareholders agreement how a mediator is selected. And then typically mediation is not binding. So are the parties just going to go through the motions, or are they actually really going to make an attempt at settling the matter through mediation? So sometimes people feel that mediation is a waste of time. So they want to go straight through arbitration, which is binding. And then the idea is, well, what type of remedies are going to be available through arbitration? Is it going to be just damages? So those are other considerations to think of when drafting a shareholder agreement, that your lawyer will ask you questions and advise you on these things. So there are other methods for breaking the deadlock as well, but I just want to touch on for some other very important shareholder clauses that we put into our shareholders agreement. So some that have to do with insurance, directors' compensation, directors' authority, piggyback rights. A piggyback right is, I just came across this in a situation. So there are 3 shareholders. One decided to sell her shares. They have a shareholder agreement, and the other shareholder decided to buy those shares, but the third shareholder said, you know what, I want to piggyback on that offer to sell my share and sell my shares as well. So now the one shareholder is buying out both of the shareholders. So, the third shareholder piggybacked on the offer and said, I'll sell my shares. That's a good price. I want to exit the business as well. So when it's all said and done, there will just be one shareholder remaining in that example. So that's a piggyback right, is jumping in on the back of another offer. So, and then death, disability, insolvency of a shareholder. These are things that should be dealt with as well. So, as I mentioned, these shareholder agreements often provide that in the event of a shareholder's death, disability, or insolvency, the remaining shareholders, would potentially be obligated, or the corporation would be obligated to purchase the shares either from the representative of the deceased shareholder, so the estate trustee, or from the disabled insolvent shareholder. So again, the important considerations here, what happens to the shares in the event of death or disability. Sometimes agreements can be made wherein, if there's disability or if there's life insurance in place, and the life insurance can be used, can be obtained by the corporation on the life of each shareholder to fund, the purchase of those shares. So it helps, because oftentimes you may have a business where shares are worth several $1 million. So the corporation will maintain a life insurance policy or a disability policy on the shareholders. And that way, in the event that happens, the insurance will pay out, and purchase the shares, or pay for the fair market value of the shares. So, those are all very important considerations. And as I said, with the shareholder agreement, there's no one size that fits all. It requires very careful drafting. So, assuming you've incorporated, you've got your shareholder agreement in place, your business is taking off. So I just want to have a quick word on employees, just because this is, an area of law that's changing constantly. So, anything regarding employees is governed by the Employment Standards Act, which sets out the minimum employment standards for most businesses and their employees. So what it covers is minimum wage, overtime pay, breaks, eating periods, leave of absence, termination notice and pay, vacation, holidays. So I want to caution you to, especially I would never advise a client to pull an agreement off of Google and run with that agreement, but I would really caution them never to do that with an employment agreement, because you have to be careful that you do not contract out of the minimum ESA entitlements that an employee would be entitled to. So that will get you into serious trouble if you do that. So I'll give you the example of this case from the Ontario Court of Appeal last year. So courts generally dislike termination clauses that seek to limit an employee's entitlement upon termination to their minimum entitlement under the ESA. So courts generally take the position that employees do not have the same bargaining power, or perhaps are not as sophisticated as their employers. So there's the law is it looks favorably on employees and doesn't look favorably on employers who don't operate in good faith or are looking to take advantage, because the bargaining power between the parties is usually quite skewed. So in this case, Wakesdale employment was terminated on a without cause basis, and he was provided with two weeks notice. So he sued for wrongful dismissal and argued that termination for cause, the clause in his employment contract attempted to contract out of the ESA and should therefore be considered void. So the company that he worked for conceded that the termination for cause provision was void, but argued that since it was not alleging cause, the remainder of the termination provision, and in particular, the without cause termination clause, was valid and enforceable. So two things to keep in mind here: he's terminated on a without cause basis, but in his contract, there is a termination for cause provision that is contradictory and is not in line with the laws as set out in the Employment Standards Act. So how did the court rule? So they ruled in the favor of the employee and noted that the offending part of the termination provision must be interpreted as a whole and not on a piecemeal basis. So the court provided an example of an employer benefiting from an illegal termination clause, or an employee that is unfamiliar with their ESA entitlements and signs such a contract may incorrectly believe they must behave in accordance with the unenforceable provisions to avoid termination. So again, this goes back to my point at the beginning. Courts are very sensitive to the difference in bargaining power between, or sophistication even between, a corporation and, let's say, its employees. So even if the remainder of the agreement, the employment contract, the court went on to say, complies with the ESA, the combined effect of contravening and non-contravening aspects of the termination provision may still need to adjust to benefit may still lead to unjust benefit for the employer, and at the end will be at the expense of the employee. So the court ruled in Wakesdale's favor, and they gave him much more generous common law awards than he would have received under the ESA minimum amounts. So it's very careful. You have to be very careful when drafting an employment contract, and even for a solicitor, you have to be careful drafting an employment contract, because the law is constantly changing. So now, based on this decision, employees now have an additional tool to combat provisions in their employment contracts that are vague, unconscionable, or perhaps unenforceable, and it could entitle them to more generous common law notice if they are not to be bound by their employment contract. So it's very important that, if you're thinking about having an employment contract with your employees, please do not pull one off of Google. The law in this area is constantly changing. It's one of the areas that changes all the time, especially now with COVID. There are going to be new changes that we're all, that are going to come through the pipeline, and the courts are always really sensitive to the struggles of employees, just because of the power imbalance. So, if you're thinking about it, or if you have employment contracts now, it's a good idea to have your lawyer review those contracts, perhaps every couple of years, because, as I said, the law is changing, and what might be enforceable now, may not be a valid clause or contract tomorrow, depending on, court decisions. Okay. So I want to touch briefly on estate planning. So you may ask, well, how does estate planning and my corporation, my business correlate? well, they actually correlate quite closely. So in estate planning, you have a number of documents. You have powers of attorney. You have one for property and for personal care, and you have your will and a codicil, which is basically an amendment to the will. You have some will substitutes, such as joint accounts, asset, beneficiary designations. I'll touch on those a bit after. You have family trust. So one important thing to note is if you have a shareholders agreement and you're thinking about drafting a will, it's important to reflect on everything as a whole to ensure that they're consistent and there's nothing in either one which contradicts the other. So it's good to take a holistic approach of your estate plan, of your business, and just make sure that everything is in line. So why do you need an estate plan? What's to consider? Well, think about this. So perhaps you're running a family business, everything is on you. What happens, if you become incapable? Is, somebody going to be there to step in for you? Who's going to manage your business in your absence? Or, who will take care of your business essentially? So a couple ways of doing this. So firstly, I'm going to touch on a power of attorney for property. So a power of attorney for property, what happens is in this document, you appoint an attorney, not to be confused with a lawyer. So your attorney, in the case of like a married couple or a common law couple, it could be your spouse who will act as your attorney. It could be a family friend, a relative, a child. So one of these people you would appoint as your attorney for property, and they essentially can manage all your property for you as if you were managing it, in the same way that, you would be able to deal with your property. So I'll backtrack a bit. So I just want to say that powers of attorneys are for when you are still living, but incapable of dealing with your property. And a power of attorney for personal care is, again, for when you're incapable of making decisions with regards to your health. So your attorney for property can look after, taking care of your home, paying your taxes, running your business if need be. So it's very important that when you're choosing an attorney, choose somebody that you trust. So trust is a big thing. It's not going to take advantage or abuse the power that you've given them in the power of attorney, but also that perhaps even has some business savvy and can take over your business and continue running it during any periods of incapacity on your part. Okay, so those are very important considerations. So like turning now to your will. So turning now to your will. So what happens when you pass away is that you're deemed to have disposed of all your assets at the time of your death. So what happens is you have to pay probate tax on your assets, which usually ends up being the largest tax bill of your life. So if there's one thing in life that's certain, it's death and taxes, no matter what, and even one follows the other. So it's important to plan ahead to minimize taxes. So remember at the beginning of the presentation, I was speaking about, incorporating to minimize taxes. Well, having a good estate plan as well helps you minimize taxes, not only for yourself, for your business, and also for your beneficiaries down the line if you hope to pass on the business to, let's say, your children or your spouse or anyone else for that matter. So, what's included in your estate? So any interest in property which is owned by you solely or that you had a right to at the time of your death. So what's excluded from your estate? Assets that are jointly held with a spouse with the right of survivorship, or assets that pass by way of a beneficiary designation or arising as a consequence of death. So in the case of, let's say, a married couple who own a property as joint tenants, if one passes away, well, then that property will pass to them by right of survivorship and won't be included in the estate, in their spouse's estate. So that is called a right of survivorship. So in that case, because it's passing by right of survivorship, you don't have to pay probate tax on it, okay? So probate tax is also commonly referred to as an estate administration tax. And also, assets passing by way of, a beneficiary designation, such as an RSP, RIF, RDSP, also would not be included in your estate and would not be subject to probate tax. So, having assets that are jointly owned, having assets that have beneficiary designations are good ways of avoiding this probate tax. Just caution you on, assets that are jointly held with, someone other than your spouse, let's say your children. is that those assets necessarily don't necessarily have a right of survivorship. Your executor will have to look at the intention behind it. So let's say you have an account joint with a child. Well, is that account joint because your child needs to access to it to pay taxes or property expenses or anything like that, or is it joint because it's really meant to pass to that individual, upon your death? So those are important considerations when thinking about joint assets. So turning now to your will. So this is where you're going to deal with your assets. So it's a written legal document which is intended to take effect on your death and sets out your wishes for the distribution of your assets and choice of who shall administer your estate. So the person that administers your estate is your estate trustee, most often in the situation of a married couple or common law couple or anything of the sort. It would be your spouse. If your spouse is no longer living, but you have children, you may want it to be your executor to be one of your children. So your executor is the one who's going to carry out your wishes and ensure that the beneficiaries get what they're entitled to under your will. They're also going to be the ones who make sure that all your debts and taxes are paid and your property is looked after until those assets are transferred over to your beneficiaries. So in Ontario, we have the ability to have what's called dual wills. So your primary will is, and I've touched a bit on this already, is for assets where there's joint ownership. So assets where there's joint ownership that become automatically become assets of the other owner. So those assets do not fall into your estate, so they're excluded. And again, assets that have a beneficiary designation would not be included. But if there's no beneficiary designation, those assets fall under your primary will. And any assets that don't have joint ownership also fall under your primary will and are included in the estate. So, property again that is solely owned by you or cash, that is included in your primary will and would be subject to probate tax. So a secondary will is specifically for shares in private corporations. So the use of multiple wills, in this case a secondary will, is particularly effective where the client owns shares in a private corporation, since it is generally considered that shares of a private corporation held by a deceased shareholder can be legally transferred in accordance with an unprobated will. So the takeaway there is you don't have to probate a secondary will, and it won't be the assets falling under that will, being the shares in privately held corporations, would not be subject to probate tax. So to give you an example, probate tax, the way it's calculated is, as of December 31st, 2019, there's no tax payable on the first $50,000 of the estate value. So that value is exempt. But afterwards, you pay $15 for $1,000 thereof of value in your estate in excess of the $50,000. So as a quick example, if your estate is valued at $500,000, you would pay probate tax of $6,750. So if you have shares in a corporation, it would make sense for you to draft a secondary will, since it is generally considered that shares in a private corporation, as I said, can be transferred without having to be probated. So you would avoid paying that tax. So if you on your death, your estate trustee gets a valuation for your shares and it's determined that the shares are worth $500,000, well then, because you have this secondary will, you don't have to subject those shares to probate, and you would avoid paying this tax of $6,750. And oftentimes, the fees for having an additional will drafted along with your primary will is it's not that much of an additional expense, but with regards to your corporation, the tax savings to your beneficiaries and to your estate upon your death, go a long way. So again, it's all about having an efficient plan from the very beginning, to minimize taxes as you move along, with your business from start to finish. So a secondary tool, is a very, it's a great tool for minimizing some tax after you've passed away. And what some of you may think, well, I'll have passed away. Like, I don't care, that my estate has to pay tax at the end of the day. I'm not going to be around. Well, again, it would be $6,750 less that your beneficiaries would receive from your estate. So, so think about, think about who would be affected by that. It may be your spouse, maybe your children. So, it would make sense, to give them more at the end of the day once you've passed on. So wills and estate planning is very important. So another effective tool as part of an estate plan can be a family trust. So it's an effective tool for income splitting and the practice of allocating taxable income over a number of persons with lower marginal tax rates. So for this strategy, if you have a family business, typically you can transfer the shares of the family business to a family trust, because the trust itself can own property, and then you have beneficiaries. So the way a trust is set up is you have a settlor who sets up the trust, and then you have trustees. So it could be the trustees would typically be the owners of the corporation, and then you'd have beneficiaries, which would be perhaps the children of the trustees. And what would happen is the trustee would transfer his shares in the corporation so that the corporation is now owned by the family trust, but the trustees now can decide how income from that corporation is split and passed on to the beneficiary. So, if there are dividends that are paid to the family trust, then the trustees can decide how to distribute, those funds to the beneficiaries. And it's an effective way, again, of minimizing tax, taking advantage of low marginal tax rates, because let's say, you have a child who's 18, they don't earn very much income, and that's often a good time to set these things up is, if you have a child who's just completing, their post-secondary education, it's a good time to start implementing this income splitting, because often they don't earn very much income. They're in a much lower tax break. So if you pay out a dividend to them, it'll be taxed at a much lower tax rate than if you were to pay it out to somebody who's already in a high tax bracket. So again, the shares are owned. Your shares in your corporation would be owned by the family trust. And upon your passing, those shares could also be, transferred and disposed of in the trust to the beneficiary, so that they essentially, will take over the business once you've passed away. So again, a family trust is, and having a will and having a shareholder agreement, these are all really effective tools for estate and succession planning, and also for minimizing tax. And these are all, advantages that are available to you once you've decided to incorporate. So, last point I'm going to touch on, because I know I'm getting close to an hour of time here, but there are generally, let's say you have your business, you've incorporated, you've worked tirelessly all your life, and you're looking to retire, or an offer comes along that just blows you out of the water, and perhaps you have children who are not interested in taking over the family business, and you want to sell. So there are two methods for selling your business. You can either sell the shares of the business, or you can sell the assets of the business. Now, the seller will typically want to sell shares, because with shares goes all the assets as well as the liabilities of the corporation. So all that gets passed to the purchaser, whereas in an asset transaction, the purchaser can pick and choose what assets and what liabilities it wants to purchase or assume. So the vendor may get stuck with some liabilities that they don't want. So oftentimes, the seller will prefer a share purchase. And also, a quick comment on employees is, if you're selling shares, well, employees go with the shares. Whereas, like if you're selling assets, well, a purchaser is not obligated to keep on, those employees. And then as the vendor, if it's an asset purchase, you would be liable for terminating their employment and paying termination pay. So there's liability with selling just shares, with selling just assets rather. Whereas if you're the vendor and you're selling shares, all the liability for the, attached to the shares moves over to the purchaser. But also, a vendor generally prefers to sell shares because of the capital gains exemption that they can take advantage of. So, a capital gain is, you pay tax on one half of the gain. So let's say, you purchase an asset for $1,000, you sell it for $2,000. That means you've realized a gain of $1,000. So then you would pay tax on one half of the gains. You'd pay tax on $500. So with selling shares, we are all entitled to a lifetime capital gains exemption of $883,384 arising on a sale of shares, which are qualified as a small business corporation. So what that means is, if you sell the shares in your corporation, you will not pay capital gains tax on the first $883,384. Like, that is a huge savings. Now, obviously, anything above that amount, you will end up paying a capital gain on. And this, I should stress, this is a one-time capital gains exemption. But for a lot of small family businesses, I mean, this is a huge exemption that you can take advantage of, because essentially it saves you a boatload in tax if you decide to sell your business down the line. So again, there are some conditions. So, 24 months prior to the sale of the shares, at least 50% of the fair market value of the assets of the corporation must have been used principally in an active business. So again, think of active business income, not passive income. So again, think of my examples of brick and mortar store. Somebody's coming through the door, purchasing stuff off the shelf. That's active business income and not passive investment income. So again, another advantage of incorporating is down the line, you can decide to sell your shares, take advantage of this big capital gains exemption, assuming you meet the conditions, which again, you should speak with your accountant about if you're looking to sell your shares, and see if you qualify for this exemption. But again, that's a huge benefit of being incorporated at the end of the day. So I'll leave it there because I'm going long. So, one few more comments that I want to leave is there's never really a perfect time to start planning for everything. Often people will say to me, oh, well, I'll draft my trust next year, or I'll get it going. Well, there's never a perfect time. It's good to begin early, update your contracts, your estate plan often, because circumstances change. So it's good to have these conversations with, your professionals. And, if you leave it later, or if you leave it too late and then you try to deal with it, sometimes it leads to, you end up spending more money trying to fix it, and you just run into more problems. Whereas if you do it properly from the beginning, you may end up with more money in your pocket, later on, but also more opportunities to try and, obtain more money and leave more money in your pocket. So, start early, speak with your trusted advisors, and then keep on top of it as you go along, and make sure that everything still reflects your current wishes and your business plan. Because, as you've seen with COVID, things can change very quickly, and you need to be prepared and have a plan in place. So, subject to any questions, I want to thank you all for joining me here today. It's been a pleasure to present to you all, and by all means, you have my contact information on the slide. Feel free to reach out to me. I love working with new entrepreneurs and helping them set up their business and their estate plan from the beginning so that we get it right. And by all means, I'm here to help.
Thank you so much, Michael. That was an amazing session. It was jam-packed with information. So I'm so excited that our participants here had the chance to learn about all these business law practices. So as you said, they can definitely get in contact with you at your email address here. We are over time, so unfortunately we can't take any questions at the moment. So if you do have any questions, please do direct them to Michael, and Michael is more than happy to help you through any questions that you may have. So thank you so much, Michael, for joining us, and thank you to all of our participants here.
Well, thank you very much again, Chizova. Thank you to the Founders Fund team. I hope I didn't overload everybody with too much information. It was a lot of these topics can need a few hours of their own to be dealt with, but hopefully the viewers can walk away with some points and things to consider with their business.
Awesome. Thank you so much. All right.
Okay.
Have a good day, everyone.
Thank you very much.
Thank you. Bye.
Bye-bye.